Establishment of a quorum. We'll start on the left.
Greg Lippy, public member.
Stan Weiser, licensed member.
Alan Chad, licensee member.
Amy Gutierrez, licensee member.
Okay, we'll have public comments, not on the agenda, matters for future meetings. Welcome back, Steve.
Yes, I would like to ask the board to put on its agenda, first of all, Steve Gray, individual, semi-retired pharmacist. I would like to ask the board to put on a future agenda the issue of when you have to look at the Cures database as a pharmacist prescriber of controlled substances. So the DOJ just released a memo describing that October 2nd, it's certified, therefore the prescribers have to consult the Cures database before any new prescription, and then every 4 months if it's an ongoing therapy. They listed all of the traditional prescribers and all of the mid-level practitioners that are recognized by the DEA except pharmacists. So I believe that the intent in the legislation was to have anyone who is prescribing a controlled substance in 2, 3, or 4 to be required to consult the database as I just described. At the later time of the legislative process, you may remember that originally the dispensing pharmacists were supposed to consult it also. And the bill was changed to exempt pharmacists, but they didn't differentiate between dispensing pharmacists and prescribing pharmacists. And since this law takes effect on October the 2nd, I think it needs to be clarified through this committee and then through the board, or maybe even with the author and the DOJ, whether the pharmacists who prescribe controlled substances also are required to consult the Cures database, as the law will then require. And there are probably over 3,000 pharmacists in California that have their own DEA registration numbers. They're doing pain management and other things related to controlled substances that, and if you want to know that they are recognized by the DEA, all you have to do is Google DEA mid-level practitioners, and there will be a complete chart state by state of each category, then which controlled substances they can issue orders and prescribe. So if you could put that on the agenda, please.
Thank you, Steve. Thank you. Been lonely without you.
Good morning, Paige Talley with the California Council for the Advancement of Pharmacy. Pardon that name. When the inventory reconciliation report has passed now and is effective, during the time that you were reviewing it, the regs, we talked about losses and maybe doing something that has to do with a significant loss, and then define significant, and I know Mr. Lippy would remember that. And Laura had said that we couldn't address it in 171565.65 because the reg that addresses it is 1715.6. So I would like to have that on the agenda. We would like to address, go back to that and try and figure out a significant loss rather than just one pill.
I think that's important. Thank you.
Good morning, committee members. Danny Martinez with the California Pharmacists Association. I'd like to request to add a future agenda item regarding the consideration of contracting for a non-resident accredited inspection agency for complying with USP standards as we start talking about implementing USP. In the past, the board has expressed some concern, perhaps some concern that there might be some limitations on inspectors' ability to travel or even just the numbers of inspectors. And we feel that this would be a good thing to revisit and perhaps consider outside contracting.
Okay, so your concern is pharmacies in other states?
No, accredited inspecting agencies from other states to
Oh.
assist with inspecting for USP compliance in California.
Other than using,
To supplement the board inspectors, so it'd be for the Board of Pharmacy.
Okay.
Thank you.
Hi, Robert Stein, KGI School of Pharmacy. It has been reported that a pharmacist that was trying to get a travel medication service established was having problems getting his DEA registration because apparently the DEA contacted someone at the board and was told that the only DEA registrations that pharmacists are able to get are if they are working in a licensed facility. So not sure where that came from, but perhaps on a future agenda, we could discuss the issue of when pharmacists do have the ability to furnish travel medications, that would potentially include controlled substances like Lomotil or Ambien, things like that, that are pretty commonly used and part of the CDC recommendations. Thanks.
Now, would that be under licensing committee, or, where should it be addressed?
I think if true, it's an educational moment, I think, for our inspectors, unless we are going to open up whether or not we want to look at Ambien specifically. I don't think the Schedule 5 drug is per se an issue, but Ambien might be. But we can work a little bit with our attorneys to see. I think it's maybe something we could clarify in the newsletter without turning it into a big deal, because the travel meds are intended to be pretty much open for the board to, or for the pharmacist to follow the CDC guidelines. So, and that's the way the law was created, and that's the way our the limited modification regs that we implemented on that read. So I think it's more of an education. So maybe we can start with doing a Q&A in the newsletter first.
Oh, good.
Thanks.
Okay. More, all right.
Joe Grasselli, University Compounding Pharmacy. Is more of a question in regards to electronic prescribing. Did we pass that we have to accept electronic prescribing, or the physician has to prescribe electronically?
We have a bill pending in the Capitol that would require the technology to be in place by 2020, and that people are to use it by 2021.
But physicians?
Pardon me?
The doctors? The
The
doctors?
doctors would be required to have the technology, as would pharmacies.
Perfect, thanks.
Okay. Oh, one more.
Good morning, Jenny Partridge, independent pharmacist. I believe what Mr. Martinez from the California Board of Pharmacy was trying to put on the agenda was to consider outside accrediting agencies to help the board with the non-resident sterile compounding pharmacies. So for example, NABP, ACHC, there's a number of organizations that have experts, and they do like for example, Texas, Florida, Louisiana, Ohio, Oklahoma. I happen to know those ones all use ACHC, and those state boards require the accrediting organization to inspect to their standards. So for example, like California, Texas has their own regulations for sterile compounding in addition to USP. And so I think what the thought process is that I know you've mentioned that it's difficult for some of the inspectors to do a lot of travel to all of these non-resident sterile compounding pharmacies, and so the consideration would be to look at some of those accrediting organizations where you could put your requirements on the accrediting organizations, but then have them use their contracted expert pharmacy personnel to help with the non-resident sterile inspections. I just wanted to clarify that.
All right. Okay. What I think I'll do here is, rather than go in the exact order that we have, I'd like to discuss the item number, let's see, where are we here? Item number,
Timing is everything, Mr. Room.
that's very nice, very nice. Yeah. What item is Josh?
Sorry about
He's about number 4, 5.
that. Like way up the agenda, so.
You trying to leave by any chance? 7. Yep.
Okay, we'll go with number 7, and then we'll go with number 9 after.
I'll be number 2.
Oh, no, you'll be number, well, do you want to give it now?
No, whatever you guys want.
Okay. Well, actually, I would like to go to number 9 and discuss the consideration of Enforcement Committee strategy goals for 2018-19 and thereafter. Right now, the board for 2016 has finalized its current strategic plan. It's the recommendation of the committee to discuss the goals for the coming year as well as the remainder of the plan. I'm going to read now the goals that are currently included in the plan. And then what I'd like to do is discuss these goals. I'd like to discuss other goals that we should address as a committee. The Enforcement Committee sees a number of problems out there. We received a number of comments from practitioners for clarification of the regulations that are provided for the safety of the people of California. If the practitioners cannot understand the regulations, if they're afraid to report problems, we need to fix that. So consequently, we do have some things that we should address. We have a number of things coming up, but immediately...
Are you recommending, Alan, that we look at this and then modify the goals after our discussion, or recommend modification?
Well, you know, I think, yes. If we're considering modification, a drastic change. You know, some of these can be interwoven to, into the strategic goals, but we should expand this.
Because this was developed, what, in 2016, is that right?
Right, and a little
Is
bit
that correct?
before that, too.
Yeah, so then maybe it's time to update them, is what
Yes.
you're saying. Okay,
Yeah.
got it.
Okay. 2.1, this is on page 8, if you're following along here. 2.1, implement processes to shorten the cycle times from investigation to resolution of cases, with special focus on prioritized cases to minimize patient harm and enhance consumer protection. This goal is we don't think we've seen much progress on it. We've seen a report that was presented, and it shows that the caseload is high, that more cases are being attended to than every year. But there's a backload. It takes, sometimes we see cases from 2011. And, you know, offering discipline in cases that happened 7 years ago is not reasonable. It's not just. And so we have to indeed do something about this. I think there's going to be a report on some progress we made, but specifically we have to develop something that can do something about it. I mean,
Alan, I'm wondering if there's a way that we can develop or the board staff can develop some sort of prioritization methodology that if certain characteristics fall into place, that case is escalated to the top. You know, either at the beginning when the claim is filed or the investigation is initiated, or after the investigation. At certain points in time in the investigation, if it hits certain criteria, it rises to the top of the pile. That way, at least we can see, because some of these issues, what concerns me and I'm just adding to what Alan said, is that if we do have an issue with a practitioner or with a pharmacy, the length of time it's taking allows that individual to continue practicing, and we could be exposing the public.
and one of my concerns as we look at these cases is the pendency period. So with this person or that made some sort of error or got some sort of citation 5 years ago, if we wait until now to move forward with discipline, what kind of damage has been done out there? Are you going to report on that, Ann, or talk about that?
So what we have prepared for today under a different agenda item is where we currently are, and some historical data will be passed out as well. But what I'm hearing you're talking about is the case prioritization that's currently used. So we can, on a future agenda item, include what our current case prioritization is. There was a change in the law a few years ago that requires the department, the director, to actually establish a case prioritization. So there's going to be a bit of a, as we bring it forward and discuss the case prioritization, there's going to be some there's going to be an opportunity to merge some things because of other legal requirements, but we have not, on this agenda, we do not have case prioritization.
Oh, okay.
Yeah,
But-
so
but-
we have general investigation type, but not specific to case
And
prioritization.
I was just reacting, just as a suggestion. I didn't mean for it to be presented today. I just thought we probably need to be looking at that.
Oh,
Yeah, so we'll make a note that the specific mechanics specific to 2.1, one of the things that the committee, as part of its process, will be looking at what our current case prioritization is, and if they want to give us direction to change some of the priorities that we currently use to assess.
Okay, and within that, I think we should have some discussion about interim discipline, if, between the initiation of the citation and the imposing of the discipline.
So when you're talking citation, I just want to make sure I'm understanding, when we note the violation, you're not talking about a citation, meaning a citation and fine, because in that case, we're not imposing.
Right.
So
You're
it's when
correct.
we identify violations.
Right.
So the benchmarks in those targets as well. So one of the things that at the staff level, I think we're hoping to get during the discussion on the cycle times is what benchmarks are you hoping we can add in? Do you know what I'm saying? Because right now, we don't identify as part of our data right now when a violation is identified, right? It's all included as part of the investigation process. So when we talk through what those benchmarks are that you want, we'll be able to then gather more data that will hopefully hone in a bit more on what you're looking for.
What is our current goal for completing an investigation and coming up to making a decision on, discipline?
So I believe that it's 540 days for cases that result in formal discipline. And that's from the time the case is received through the effective date of the decision.
And was that based on looking at the staff we have and so on, or how was that determined?
That was determined several years ago through the Consumer Protection Enforcement Initiative. That was like 2011, 2012, somewhere along there. One of the things that the department did was worked with each of the boards to establish what those performance measures would be. Some of that data is under other agenda items within this. And so we developed cycle times, performance measure cycle times, based on the benchmarks that the department had determined. So it's intake time, it is investigation time, and then formal discipline time, probation time. So there were benchmarks identified by the department.
Josh, you gonna?
I just wanted to say that in answer to Greg's question, my understanding is that 540 days was always aspirational and was not based on existing timelines. I'm not sure that 540 days has ever come close to reality at this point. If you're talking about time from receipt by the agency to prosecution by my office, I don't think, as we'll discuss when we get to my presentation, I don't think it's reasonable to expect the case to be completed within 540 days in at least some of the cases. Maybe you can, if you average in enough of the small, easier conviction cases, but for the standard of care cases, those take a lot longer.
And what is the reason? Is it due to lack of staff, due to lack of
It's all of those things.
AGs
I don't
or-
want to.
Well,
I don't want to give away too
He
much.
doesn't
of
want to
the-
give away his presentation here,
Oh,
But yeah,
okay.
I think there's lots of things.
Edge.
I think there's, just to sort of generally answer your question, when the CPEI came in at the sort of agency level several years ago, and in response to that, several of the agencies were given additional staff to process cases and investigate cases, so they were able to push through more cases. There was not necessarily a commensurate increase in staff in our office for prosecuting those cases. So having 30-something agencies all pushing over more cases at the same time just creates even more of a bottleneck and backlog at our office in terms of, we are now staffing up to but it's just staffing up at different times based on perceived need and the legislature's willingness to fund positions and all that kind of stuff.
Is there a way we can do something like in egregious cases, like a restraining order or something like that in the meantime?
Yes, we do have,
No,
we
I know
typically.
Ann's done that. I mean, there's an interim suspension order, right, that you can do.
The interim suspension orders, we have the Penal Code 23s that we use in criminal matters, and then we have the cease and desist authorities that we use for both the unlicensed activity as well as for sterile compounding. And if we needed it, I believe we have it for the outsourcing as well.
Can I ask a question about the days? 540 days. Are we talking about day one being January 1st and then all the way through for 540 days, a year plus? Is every day is every week a 7-day or a 5-day week? Are we talking about 500?
We're talking about calendar days, not business days.
Okay, good, thank you.
Yeah.
Kind of wondering why in the very publicized J. Scott case, why we wouldn't have done something like that. They killed 5 people and they continued to practice for 4 years or 5 years. Why wouldn't we have done something like
Without
that?
pulling the case, I can tell you that there were multiple agencies involved, and sometimes we have to step back and let other agencies do things, and we try to work cooperatively with them, but sometimes we step back and let them do it. We are not criminal prosecutors. That case also went criminal, I believe.
Would it be possible, though, for the board or the board staff to come up with a list of criteria that would indicate a potential interim suspension order so that when those cases are reviewed, that you could say, okay, it hits these 3, let's consider it, so it moves forward? Would that work?
Well, I don't think there, well, I'm not,
doing
I
that
don't
now.
think there's a shortage of requests for interim suspension orders. I do think that the cases that are even potentially eligible for interim suspension orders are being highlighted to my office to seek interim suspension orders. If anything, I think my office probably pushes back on some of them, saying that those are not appropriate for interim suspension orders. That may just be based on, workload and capacity to handle all the different expedited requests that we get from all of our different agencies. So that doesn't necessarily mean that that case couldn't possibly get an interim suspension order. It just might be a weighing of prioritization, particularly in LA, where we've been severely understaffed for a number of years, and we are now getting a huge influx of staff in LA. So hopefully within the next 3 to 6 months, LA will be much more amenable to receiving those requests than maybe it has been able to be in the past.
Your staff actually works on the interim suspension orders.
Yeah, we have to present them
Got
to
it.
the.
How many have we issued in the past year?
Quite a few. I can probably find it.
And they are to pharmacies and individuals, right?
Yeah, so we have issued 7 interim suspension orders. We secured 4 automatic suspensions on a conviction. We secured 8 Penal Code 23, which are also criminal, and then we've issued 1 cease and desist for sterile compounding. What's not on here are the cease and desist for unlicensed activity. And I believe that we've done at least 2, so I apologize, we have not updated our records for that.
That's year to date.
Yes, this fiscal year.
Fiscal year.
By my count, I think we've done at least 2 cease and desists based on serial compounding, but I don't know. Just in my head, I think I can think of 2, but I might be wrong.
We'll validate our data.
No, I believe we've had 2, and I know that there was recently a 1 for unlicensed activity too, so I can think of 3 right off the top of my head.
Okay, to move on here. 2.2, strengthen patient consultation outcomes for Californians, increase medication safety. Status, the board is seeking to strengthen patient consultation requirements for mail order pharmacies. In addition, the board has received general information about board investigations involving patient consultation violations and efforts taken by district attorneys reaching settlements as a way to gain better compliance. The number of violations that we've found for consultation seems amazingly low for the emphasis that we put on it. We should come up with some specific goals, actions, or something like this that we can show that we've got some sort of improvement, or we should just give it up. You know, I mean, this is federally mandated, it's California mandated. And so this is just kind of window dressing that indeed we should do something about it. But if I were asked, you know, what have you done? I'm at a loss. And I've got no data to really grasp on to.
So, so I think at the staff level, we agree. And so I think that we have a couple of opportunities for some improvement here. I think one of them is partnering with the AG's office to give us some guidance on better ways to substantiate the violation itself. It's kind of hard to prove sometimes from an evidentiary standpoint. So I think we need to probably partner with the AG's office, because they'd be the ones representing us, to make sure that we are approaching it the best way possible in terms of evidence and substantiation. So I think that that's one big thing. One of the other things that the committee kind of talked about at one point was whether or not we should also be, in terms of assessing fines or things, one of the things that you guys had talked about before is when you're assessing license history on these kinds of things, should we be looking at resolving those in a different fashion than what we currently do. So if you could give us a little bit of time, we'll continue to collect the data. At the last meeting, I think we indicated that there were 65. Give us an opportunity to work with the AG's office, implement some changes in how we're currently investigating them, and then we'll continue to give you numbers, and then maybe after we've implemented some of the investigative changes, we can then take it to the next level if that's agreeable.
Yes.
Can I ask a question? I know that when we talked about this before, there were we would ask that there be a review of certain chain drug stores and their process for counseling, so that electronically you could actually exclude and not be counseled. And that's just part of their workflow. And that would be an easy way to kind of get at this from a larger scale. Because if I can go into a pharmacy and I can check a box to refuse counseling there, or to not to a pharmacist, that doesn't seem to be a way that's against the law, right? They have to refuse it to a pharmacist. So can we look at some of this electronic workflow that's in some of our large-scale pharmacies?
We don't, well, yeah, maybe this is legal. Maybe you better
Well, I was
answer.
just going to remind the board, I think all of the members of this committee were on the board at the time these actions took place, but I just want to remind the board that, what was it, 4 years ago now, or maybe longer?
2015
Yeah.
was the first one.
There were cases brought against 2 of the 3 largest chains.
4.
Oh, 4, sorry, my
We've gotten
mistake.
4 chains.
4 chains for exactly this issue, sort of on a chain-wide basis, because one of the difficulties for the board is that the enforcement mechanisms that are available to the board are only site by site. And I don't mean citation by citation, I mean premises by premises. And so to achieve real and lasting change, a better option may be these, chain-wide, not to say that independents aren't also, needing to do consultation, but just in terms of, getting the most bang for your buck. And so I believe that it's possible that more of those activities could take place, more of those kinds of, especially given that in settlement of those prior cases, certain agreements and obligations were imposed. So violations of those may be easier to prove than the underlying violations themselves.
Might just be one way to attack it on a larger scale, because most of the pharmacies right now are one of the 3 big chains. I know Greg mentioned yesterday that do you ever refuse counseling to a pharmacist? That's what you're supposed to do. I actually do. The pharmacy I visit, I do, but he says he doesn't.
Yeah, likewise. Yeah.
No, I usually there's a little box there on the counter, and it says, I refuse, and the person that directs me to it is the clerk.
That is a violation of our patient consultation law, regardless of whether or not they use the box or not. The denial has to go to the pharmacist who has already initiated the consult. So if they use a box to have it ratify, if they're doing it as a pre-screening, that is a violation of our law, which gets back to what Mr. Shad was just saying about 65 violations isn't even close. Right.
Okay.
All right, but so nonetheless, it's a difficult problem. It's kind of nebulous, but we should have some
Priority.
steps that we can maybe even brag about.
So we'll, at the staff level, we'll be working on the investigation piece, but then we will segment out that data specifically for you so that you can see how it's going as we start completing these investigations.
Yes, so we can have, as Josh said, some real and lasting change. Yes. That's very nice, very nice.
I'm
Josh.
so quotable.
Okay, 2.3.
Or what?
2.3, collect data to report to board members about enforcement trends that are presented at case closures, so the board has can better educate licensees about board priorities. We've been discussing this somewhat. Multiple year enforcement statistics were provided at the what meeting was that?
So we give them annually. At each July board meeting, we give a multi-year comparison. But this, I think, will also feed into a discussion that the committee will be having about what information that we're providing is valuable in terms of our enforcement stats and what ones would be more helpful to assist in the identification of the trending. So right now we give some, not sure that it's utopia. We want to make sure that the data that we're collecting and providing to you as well as to the regulated public is meaningful. So that'll be good discussion.
Great. Okay, number 2.4, evaluate technology trends and develop future regulatory infrastructures that promote patient safety. We did have a board technology summit. We had pilot projects expanding the use of ADDS. And we're trying to get some legislation for a regulatory framework. This is moving along slowly, but there are other priorities, I think, that are going to come to light. This is going to be ongoing.
But we have the legislation of the board sponsoring
Right.
on the technology.
Right.
Yeah.
Right. 2.5, evaluate the disciplinary process and initiates process improvements for enhanced efficiency and effectiveness. We've mentioned this, and I think we're going to have a little more discussion on this soon. 2.6, collaborate with stakeholders to identify and expand resources for technicians who experience substance abuse and provide assistance in recovery. There'll be more discussion on this as the meeting goes on, I think. And also in 2.7, investigate options on the interoperability with the National Prescription Drug Monitoring Program. And is there any progress on that? Hetty?
Pending.
Oh, I see, okay.
All legislation is in some way pending.
Oh, all right, Josh, please.
Okay, well,
My ex-husband's name just popped out of my mouth on that one. I couldn't restrain myself.
well, some of the other things that I think that we should address as part of the our goals, and and help the profession, help patient safety, because our laws and regulations are made by definition to ensure the health and safety of the public. And the practitioners in our profession, in order to provide this safe care, have to understand the regulations and how they're enforced. And like I've mentioned before, we've had several board members have expressed concern with the feedback that they've received from pharmacists in practice, particularly the pharmacists in charge. There's confusion about the consistent enforcement of compounding regulations. There's fear of retribution and further expense and punishment if inspectors or the board is questioned. This is a real fear out there. There are examples that have been presented that seem to bear this out, and pharmacists feel at risk, their license is at risk if discipline is questioned. This is very important. I think that there should be a process for pharmacists to anonymously complain to the board about the inspectors and the inspections. And I believe that this committee, or else the board as such, should be apprised of those complaints and what's being done about them in a timely manner. This is not an unusual type of system. I think the state has it. All large organizations have it for ethical variations. So some sort of anonymous system that provides some recourse for the pharmacist to take. And so I talked to the board president about this, and he thinks that this is something that is particularly important at this time. Any comments on that?
Are you referring to like a phone system where someone, or an online reporting system, someone could report anonymously?
Well, I don't know what's available out there. I know that.
Do other boards do this at all?
I don't know, but we're happy to, I've marked it down as something to explore. So perhaps this is one where you can, direct staff to look at some possible implementation options in terms of meeting the strategic goal. Like, this reads to me like this is about a transparency piece as much as anything else. So it would be developing some sort of a mechanism where people could report in, and then a transparency back out. I think just being perfectly candid, I think one of the challenges with anonymous is sometimes you need to follow up to get additional information. So that's going to be something that we're going to have to kind of struggle through a little bit. Like when we get an anonymous consumer complaint, it's really hard sometimes if we're not given at least sufficient to be pointed in a direction, it's really hard to follow through. So it makes it there's going to be some challenges that we'll have to kind of work through. But this is setting the policy, like the goal of it, right? And then we'll work towards it. And if we have to refine, that's what we do.
Right. Nobody likes getting a ticket, and everybody's innocent. I know that.
But couldn't this help, like if we had a rogue inspector out there? So if you're getting anonymous complaints about John Doe, that will at least let the board know we may have an issue with John Doe. Maybe we need to have a supervising inspector look at it.
Part of that, I think, though, would be viewed as employee discipline, and that's really handled in-house, not typically by the. So we're going to have to develop some kind of feedback mechanism that we somehow keep you advised of what's going on there. But I think we will have some collective bargaining problems if we open it up too far to the public. So.
No, that is problematic, but and I certainly understand that. The board as such can't get involved in the department matters like that. But, I want to be able, as a board member, to be able to say there's a process, there's a easily accomplished way of doing this. So I can say that we have a method to hear your complaints and determine if they're valid or not. And that something is done about them. We don't have to know specifics. But something out there that we can present to you complainers out there that something's done, and you can feel justified that something perhaps has taken place.
And I didn't mean to infer the board would do that, would follow up, but I'm just saying there's a process where you and maybe you would follow up, or there's a way for us to get, because I think what happens then is we get emails, and I know Alan's gotten some, I've received some, I'm sure the other board members have as well, but if we had a venue for that to happen, at least it would go to you directly.
Well, they need to come to me, seriously, and then we'll find some way to report it within the system.
But, you've said oftentimes, they should contact you. Well, everybody's afraid to contact you. And
I spend a lot of time going to meetings, Alan, so that
nonetheless, I feel we're blaming the victims. And no matter how long you're out there, you're part of the organization. So we need some way that the professionals that are providing this care can feel that they can bring up topics of concern that will be taken care of. It's a difficult situation to be in, and there's with anything that if they're pharmacists and pharmacies are afraid of getting in trouble, and there's expense and there's time involved in that, and as a matter of fact. That's one of the things that I want to look into, too, is the consequences of discipline that the unintended consequences of discipline that we enforce. Just yesterday, we heard about the cost of Maximus being so outrageous. We heard the cost of ethics courses being unreasonable, $2,000 and more. As a matter of fact, a lot of times when we enforce discipline in California, if we put a pharmacy on probation, Express Scripts will say that's a breach of contract. I know of one case where a pharmacist got put on probation. Express Scripts said this is a breach of contract, and he couldn't fill Medi-Cal prescriptions for 3 months. This is a loss. This is a greater loss than we anticipated, and this is difficult to find because there's nothing out there that says Express Scripts will do this, and but all these violations of contracts. This is something that goes on out there that we don't know about. And there's cases of discipline where we put pharmacy on probation, and so the other states put the pharmacy on probation, and all of a sudden, it's a cascade of expenses. And the state, like I said, has deep pockets, and practitioners have shallow pockets. Well, some have deeper pockets, but yeah, so I'm you know, I want to follow up on this, and also,
Want to amend the goals? I mean, add this as a goal?
you know, I would like to, yeah. You know, the fact that well, pharmacists in charge of places feel at such risk. So I'm not exactly. There's been the issue of feedback. There's the issue of responsibility and picks. There's the issue of unintended consequences from discipline. I want to, as a enforcement committee, I want to look into these things. So
maybe create a goal that states that we develop a process for anonymous feedback from stakeholders or licensees that at least the board gets a report. How's that as one of the amendments to the goal?
well, you know.
As one, I mean, I'm saying that's not going to encompass everything you said, but at least to start
well,
out there.
I think that's a good starting point. So that the motion was?
The motion was to amend, add a goal on here for the Enforcement Committee strategic goals to develop an anonymous feedback mechanism, however staff believes is appropriate, with a regular report coming to the board of the outcome of that review.
Second.
Board discussion?
Wait, our council, did I do something legally
well, no,
wrong?
I don't think you did anything. I think, though, that aren't the strategic goals set by the board itself? So you're
We
making
can make a recommendation to the board.
to
Yeah.
modify the goals?
That's how it was phrased.
Okay.
I heard other things that you had on there that we need to probably amend, but I'm just starting out with
That's
one.
a good start. That's a
Okay.
good start. Public comment? Or board comment?
While you're modifying, what you have done is set the table with a huge plate of thoughts and for the next year, it seems.
Right.
Awful lot.
Yeah, it
And
is.
so I would suggest to you, while you're modifying, when I look at what I have in front of me today about future dates for meetings, so we have our next meeting coming up September 8th, December 13th, and in 2000, this is during this next year, assuming that chairmanships are for a year, and I hope that you're chairman for the next 10 years, but the chairmanships are for, talking about 4 meetings. So I would suggest that, you know, this aggressive agenda that you have put forth accomplish all of this, but, you know, ripple effect because of staff.
Oh, right. And I think that's a great idea, because I like seeing the staff, I like seeing you.
I like seeing you.
Yeah.
But I agree with Stan, if there's a lot of work ahead, it probably would make more sense to have more frequent meetings.
Sorry, because we're kind
There's
of
a
jumping
list.
all over the place, so I apologize. But
Yeah, but
we
I'm
do
saying
have, we passed out the possible meeting dates for next year, and we are increasing the frequency after June, because one of the other things that this committee is going to have the opportunity to work quite quite thoroughly on is the implementation of the revised compounding chapters for 795 and 797, and then implementation of USP 800. And because those become final in June of next year, we did increase the frequency of meetings the second half of next year, primarily because we were like, that's going to be a lot of work. So as we're making some of these, maybe the committee may want to establish some earlier on to try to get through some of these, but some of these, maybe it's policy goals that get us through the strategic plan as opposed to just next fiscal year. You know what I'm saying?
My observation is that, currently, the current president chooses the current chairs for committees, and the president's term lasts for a year. And so, hopefully that there will be continuity with the leadership of the committee with regards to the ability to achieve items that forth. And but the only thing for sure is the next 4 meetings, September, December, and as you say, the schedule that you put together for 2019. But if the presidency changes next year at this time, so.
Good point. So we might schedule a couple more meetings? We'll work on those dates. Oh. Well, I said, yeah, for 2019, but 2018, we can have a couple more, too.
Well, actually, indeed.
Oh, indeed, indeed.
I thought this was just replacing it. I didn't realize that we actually had a couple of months here without enforcement meetings.
Okay. Public comment? Well, no, for the motion that we're discussing.
The motion that I made?
The motion you made.
Okay.
I want to note that CPHA fully supports this motion and is willing to work with the committee and staff to making it as easy as possible. We love the idea of this sort of anonymous mechanism to report complaints. I've said it before, we've heard it here again, that yes, pharmacies are afraid, rightfully or wrongfully so, they are afraid. And so one of the things I'd like to suggest is something that the committee could consider, perhaps creating some sort of ombudsman's office for receiving these types of anonymous complaints. But I don't know if you'd house that within Ginny's, under her staff or separate. I don't know. But it's something that I've seen work in other areas of government, just something to consider. But we fully support that and are willing to work with committee and staff to achieve this.
Thank you.
And Chairperson Shad, would you like us to take a vote on all of the amendments to the goals, or would you like to do them one by one?
Let's do them one by one. That'd be more
Okay.
clarity, I think.
Okay.
So, vote. All those in favor? Opposed? Abstain? All right. Okay.
So what's the other items that you have on there? I think it was review some of the enforcement actions that are taken, the citation and fines. Is that the other one?
Yeah, we want to have more transparency. We have more awareness. I think, Ann, did you have a couple comments on this?
Sure. So specific to cite and fines, at the last meeting, you all had, at both the last enforcement committee and then at the board meeting, you had a presentation on the citation and fine process and concerns about transparency and things like that. At the staff level, one of the things that we would like to bring forward as something for the committee to consider, as well as the board, is developing some kind of a policy where board members, it would have to be individually, single at a time, join staff in citation and fine office conference appeals. And so they'd be hearing the office conference appeals. That will give board members an opportunity to see more of the investigation, the evidence and things like that that is not normally available to you, as well as sit through the process and then talk through things. It will provide an opportunity to collaborate with staff, to provide thoughts and opinions on things, as well as see how the process works. And so that's one of the recommendations that we were considering.
So, I mean, that's really detailed. I think it would be great. I would like to, is there a possibility for the enforcement committee to see the closed cases on Cite and Fine? So we could see what actually, because one of the things, and Alan's seen, you and I were at CSHP last year and got quite a lot of questions, and there's a perception out there that the board knows what goes on with Cite and Fines, and we don't. It's just, we just see the cases that are voted on. So is there a way to look at more of what's happening and maybe to help set policy on some of these?
So absolutely, and I think under one of the other agenda items, you're talking about making citations and fines publicly available. So it could be done through that. I think what we were looking at from the staff level was, in addition to that, it was not meant to it was not meant as a replacement to that. It was more like for board members that are interested in seeing how it works and what the process is like. It just gives you an opportunity from a transparency standpoint to be more involved in it, at least on an occasional basis. We have not talked to our council yet, so I'm worried that there's, but we were thinking it could be one board member at a time. And then, of course, if that appeal went on beyond, that board member would be recused from any subsequent things, but it would be a way for people to see the process a little bit more transparently.
And right now, in terms, and I wanted to ask Laura this from legal counsel, in terms of the Cite and Fine, how that dollar amount or the citations arrived at, you can't really set guidelines for that, can you?
The board has set guidelines, and you've done that through regulation. So how you would revise that is by revising your regulation.
And, I'm unaware of where that is, where,
If you give me a second, I can pull it up, but I think we talked about it at our last committee meeting, I think,
no, so,
It's 17,
73, 75, somewhere around in there.
75.
and it says,
1775.2 specifically, which says, in assessing the amount of an administrative fine, except violations of the Confidentiality Medical Information Act, blah, 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 and it just gives a bunch of factors, the gravity of the violation, the good or bad faith,
okay.
those kinds of things. So it's just general factors. Anything beyond that is difficult to do in a way you can be placed in regulation.
okay. Well, we did get information at the last, was it at the last committee meeting, about the average fines, about the, of course, that's sometimes, the average is sometimes, not, yeah. So,
would it be worthwhile maybe having the enforcement committee just put on the agenda to review that regulation and see if we need that? Would there be any benefit in that?
there might, yeah, I think so.
How old is that reg?
It looks like 2003 was the last amendment.
That's only 15 years ago.
So what if from a strategic plan perspective, it's developing some kind or recommendation to the full board to complete a review of the board's citation and fine program, including it's a policy goals, right? So keep it high level, and then within that we can kind of develop what the mechanics might be to do that, including a review of the citation and fines, more regular data collection, those kinds of things. So keep it high level for the strategic policy goal, but make it you want to do a thorough and in-depth review of the citation and fine program, and that could be an end-to-end review.
Okay.
Yeah, because I'm just reading 1775 right now. It just says the executive officer, his or her designee, may issue a citation, which may contain both an administrative fine or an order of abatement. And it just says a violation of the pharmacy law.
Look at point 2.
Point 2 has more?
So is this a motion to?
Yeah, I would make a motion just to have the enforcement committee review it and look for some potential options.
Second.
The motion is specific to the regulation or the entire cite and fine process?
I'd say
I
both.
apologize.
I would say both. You okay with that, Greg?
The entire cite and fine process would sort of, from my perspective, include the regulations.
Right.
So maybe you
Right.
only need the broader.
All you need is a process.
That's fine.
Got it.
We've had board comments. Any more? Great comments? All right.
Steve Gray, a pharmacist, on the subject of the cite and fine and the discussion, which I am in favor of a complete review. I would just like to add, I might be the only one here that was around long enough to remember when the board had a different process. It was the Northern Interim Committee and the Southern Interim Committee, and they would meet, and there were pharmacist members on those committees. And the public was invited. In other words, later, I think someone in the department said, no, those had to be private meetings, and so we no longer got to sit there and listen to the discussion of the other. It was very educational for us because we got to hear what other people were being called to task for and what the board's analysis was as to why that was a problem, et cetera. But one of the...
Steve, just a question, was this before, so every citation and fine would require a review by the
I
committee?
think it was actually before there were citation and
It was
fines.
before there was citation
Right.
and fines. It was a way of handling violations that probably were not going to result in formal discipline,
Right.
but where violations of the law occurred. And so there would be an agenda posted. The actual investigation or summary of the investigations, I believe, were available as a packet. The charging section was laid out there, and it was a very open process. The problem is there were concerns about whether or not that was sufficient due process, because people were being perhaps labeled with a particular violation that may not be sustainable.
Right. So
And
I'm not
there was a lot of
advocating that
concern.
it be open to the public or something, but there was one adverse effect of that I want to call to your attention. And that was that when you had board members sitting in on the interim committees, and they would rotate through, not only when they became new board members, but each year they'd be assigned. We noticed, kind of like the inspector problem, there was a wide variation in what the decision was and even the philosophy expressed, because now you had different board members being a part of the discussion, and there could only be two, and so it wasn't the whole board. And so if you go down the process, I'm not saying it's wrong, just remember that you're adding another level of variation, and the board members had different passions about what they thought was a more serious violation versus something else. So depending on who you got sitting there at the Southern Interim Committee or the Northern Interim Committee, the discussion varied and the results varied quite a bit. So just keep that in mind. I think it's a great idea for the board members to understand the office conference process. I just don't know how to do it if they're sitting in there and expressing their opinions and judgments. You're going to get that variation all over again, and especially over time and as it changes. So,
I'm sorry. On that particular note, I don't believe that the board member, under the current laws and regulations, the board member wouldn't have a vote, if you will, about the cite and fine. Right now, the way that the statutory scheme is
Right.
established,
Right.
that authority lies firmly within the executive officer, and then that the appeal therefrom, which is a possibility, and that goes to a full administrative hearing, which would be handled by the Attorney General's office.
but what I'm talking, but I think that's a little different. What I'm saying is you appeal it to an office conference, so a fine and a citation have already been issued. The office conference is where they're going to receive more information and then go away in the back room or however it's done and talk about whether you're going to uphold the citation, reduce the fine, et cetera. In that process, I see a risk of wide variation because that board member is going to be there expressing their opinion, their influence, and their position of authority. And I think it's going to affect significantly whether this citation may be revoked or not revoked, depending on what individual board member participated in that discussion. So maybe there's a way that they can participate in hearing the evidence, but not participate in making the decision. That might be the way to go.
Yeah, that's my concern, is that I don't know that they would, under the existing statute and regulations, I don't think that they would be permitted to make the decision.
But I think Steve raises a good point, and was what I was going to mention as well, is that if the board member's there, and at the office conference, the executive officer or the supervising inspector, who's ever there, has the option to basically agree and drop the citation, you would have the opinion of one person there in that. So I think that's a good point.
Yeah, it's just something to be aware of because,
Yeah.
sometimes these things that sound like a good idea, we've tried them before and it didn't work out so good. And then I do want to go back, Mr. Chairman, to 2.2 when you're ready to talk about the consultation goal. I have something I
Say
want
again,
to.
Steve?
On agenda item 2.2 on goals, about consultation,
Oh, uh-huh.
I would like to have some comments on that when you're ready to go back and talk about that in
Oh,
general.
all right, all right.
Okay?
Look forward to it, Steve. More comment? We've got a motion? All those in?
Second.
And a second? All those
It
in
was
favor?
Amy and Greg.
Those in favor? Opposed? All right. Rest of the topics we talked about will be discussed. I think the rest of the topics we've mentioned will be discussed in.
Do we want to put on the agenda just some of the costs? I think you raised that as an issue as well. Whether, do we need, are there other
Oh, we
options
should-
for ethics classes that doesn't cost $2,000? Are there ways that we can maybe expand more providers to lower the cost? Things like that.
You know, we haven't mentioned the unanticipated, and so if we could entertain some sort of motion so if we could entertain some sort of a motion to investigate the unanticipated effects of,
I'll second.
okay.
Just to review the costs, I think the enforcement costs, and then also identify options for alternatives to reduce some of those costs.
Right, right.
Just to clarify, it's like post-discipline? I
Right.
just want to make sure that I'm getting the right.
Right.
You know, you're concerned about like the Maximus issue that we ran into yesterday and things like that.
In some cases, we lost the revenue.
Right.
Right, okay, great. So that, we've had the board discussion, public discussion? Pardon? On the topic, yeah.
And
So, and like an example would be, we have, how many providers do we have for the ethics course? Is it 2? If we had 5 and we had more options, could we have a little more competition so we can lower some of the costs? Things like that.
Yeah, it should be looked at, you know, whether it'll improve, I'm not sure, but nonetheless.
Just part of the discussion.
so
Got it.
specifically, is the board motion focused on the financial implications?
So here's what I wrote down.
Any unintended consequences.
I said recommendation to assess the enforcement cost post-discipline and search for options. It's rough, but a recommendation is an assessment of the enforcement cost post-discipline.
I think it might be better to say collateral consequences of discipline.
Oh, that's good.
Because
Very
it
quotable.
includes costs, but it also includes things like loss of revenue or.
Yeah.
Yeah, that's a
Great
Very
idea.
implicit. Should be around more often. Yeah.
I think I might be done for the day.
You're going to leave while you're ahead, is that it? Is that what you're saying?
And again, this is a recommendation to the board to amend the strategic plan to include this as a goal, correct?
Good, good. Okay, all those in favor? Unanimous.
Magnanimous.
Oh, we're rolling here. Okay. Now, there was more, I think, like I
Going
said,
back to the beginning?
well, I think we've got, go ahead.
One thing that we're finding at the staff level, if you don't mind, is we're running into cases where the consumer is reaching out to us because they've received a partial fill on a prescription. And so the pharmacy is giving them the partial fill, they're going through, they're adjudicating the claim. But then when the patient is going back to get the remainder of the prescription, it's not, the claim is being rejected by insurance, saying it's an early fill or whatever else. Would this be something that that this committee might be interested in, the board and staff, collecting additional data in this area, because it does seem that there have been instances where it's resulted in a delay in therapy to the patient through nothing that the pharmacy is doing at all. This is not, I don't think that this is a problem that we can necessarily fix, but we could perhaps collect data and note the impacts to patients in this area, and then perhaps reach out to other regulators that could maybe then effectuate some change.
Go ahead.
So that I understand it, I go in with a prescription for 100 Lipitor, of which I take 1 a day, so the pharmacist, my max on my insurance is 30. I have 30 and I have 70 still available to me.
So I'm more talking about you have, so an example is diabetic chest strips is the case that's coming to mind that I recently, and so the consumer was supposed to receive 3 boxes of it, but the pharmacy only had 1 in stock. So they adjudicated the claim, they dispensed the 1, so then the patient went back, and because then I don't know, the magic of the computer system. When they were trying to adjudicate the remainder of the claim, it was declined, saying that it was an early refill. In another case, the patient went in, the pharmacy only had a certain portion of the antibiotic. So the patient received the starting of the dose, but then because it took so long to then adjudicate the remainder of the claim through the insurance, the patient actually went without the antibiotic for a couple of days because the remainder of the claim could not be processed through insurance.
Isn't that more of an insurance commission issue?
Yes, and that's why I was saying, I don't think that it's something that we can necessarily solve, but is it something that you'd be interested in us collecting data so that we could then make an argument to these other, so what we do right now is we refer them on an individual basis to Department of Insurance or Department of Managed Care, but sometimes it's data is what drives the policy change, and although it might not be a change that we could effectuate on our own, we could perhaps provide another agency with sufficient information. We're getting the complaints because the consumers don't know where to go.
Well, it does seem like a pharmacy problem. It's a process problem. I don't know the intricacies of retail pharmacy billing, but it seems like they would have to bill for the amount that's dispensed, and so consequently, if they don't have the full amount, then a problem ensues. And so I think we should look into this because it is a problem that I've heard about. You've received several complaints, and if we can articulate it a little bit better and look into the subtleties of it, we might be able to switch over to someone else that can.
To me, it seems like a very unique thing, but I may not be understanding the problem. So somebody gets a partial fill on a prescription for a complete therapy of antibiotics. So they're supposed to get, let's say, a 20-day supply of antibiotics, and the pharmacy only had 5 days supply. So my experience has been that you make a claim for the total amount, and you give the patient 5 days supply, and the patient comes back and gets the other 15 days supply, and the total claim has been made for the entire therapy. You know, I can't imagine I mean, it's got to be really extraordinary. But again, I haven't done it for a while, to where a pharmacist gets a prescription for, 30 C-chlor and fills it for 10 and only bills for 10, and then fills it for another 20 and tries to bill for the other 20. But
Well, I think I mean, at least in my experience from an enforcement perspective, I agree that is standard practice. What becomes very problematic is that if the patient never returns and the drugs are returned to stock, but the billing is not reversed, or there are, say, overlapping prescriptions for that patient, and so it's very difficult. It becomes clear at some point that the pharmacy is coming out ahead in terms of billing for more than they've actually dispensed. And so that's come up in a lot of cases, or at least just anecdotally, I've seen it a lot, so I assume it's a fairly widespread problem. So I do think there's some, discrepancy or problem between what seems reasonable at the time, which is I think you're right that insurance companies expect you to only bill once for each prescription, so you bill for the entire amount. But then how the reconciliation of that on the back end doesn't always seem to be consistent about how people are doing it and keeping track of how many they owe that patient, essentially.
Well, you're damned if you do and you're damned if you don't, because so if you bill them twice for the same 30 pills, now you have gotten 2 dispensing fees. Right. And so the insurance company can come back and say you split it, for the purpose of financial gain. If you bill them once, with the expectation that they're going to come in for the balance of their therapy, it's only been 1 professional fee. Right, so I understand.
Isn't there a provision for getting credited back if they don't fill it?
Right, they should be crediting back the return to stock. So that's the biggest, and I think most do. So the cases that come to my knowledge are the ones where people are not doing that, either through oversight or for greed purposes.
That's their problem.
Yeah.
And the way that I would do it is the only alternative is to credit it back for the full quantity, the 30, instead of the 10 that you're returning to stock. So it's a quagmire, but it's extraordinary, I believe. But evidently it isn't.
Public comment?
Steve Gray, independent pharmacist, but with a long history of managed care, former president of the Academy of Managed Care Pharmacy at the national level. And we had a task force, actually, I started the task force to reach out to community pharmacies and try to solve problems like this. A lot of them were solved. The answer is yes, we did. I think Josh Room is exactly right. This is more of a problem now because Medicaid and Medicare are strictly enforcing with big penalties if you don't reverse the claim or other things. And one of the reasons I came up here right away is because this is going to get bigger July 1. July 1, the law was changed to have partial fills on Schedule 2 prescriptions, both at the federal and state level. And so now people are going to be able to get partial fills and at the federal level, and that starts July 1. The copay proration doesn't start till January 1. So you're going to get a bunch of complaints that the copay isn't being prorated because the law, the managed healthcare and insurance couldn't figure out the algorithm by which to prorate the copay, and it is complicated. So the copays may not be prorated on the quantity that you got until after January 1, 2019. So they got 6 months in there. But here's how it works, Stan. You got the prescription for 1 a day for Lipitor. You got 100 dosage units. Your drug benefit only covers 30 days. So if you want, you can pay the copay for the 30, and then you can pay full price for the balance if you want. That's not usually what happens. So they break it into a 30-day, and they issue the 30 days. There's also rules in there about the percent of days supply left when you come back. So if in 30 days, let's say it's 20%. Well, 20% of 100 days is you could come back, with still 20 days left and order your next refill for your next 100 days. 20% of a 30-day is only, it's less, it's 6 days. And so depending on when you order the next one, your claim's going to get rejected. Now, it's more complicated because now if you do what you used to do, we all used to do that. We used to say, okay, we're going to put in the claim for 30-day supply. I only had a 10-day supply, come back and get the rest. And then when if you came back, no problem. But now technically, that claim goes through, let's say on the first of the month, and we only gave you a 10-day supply, we've committed fraud because on that day, the transaction shows, et cetera. So, and then there's a transaction fee that is charged by the PBM for just processing the claim. Then when you give the credit, there's a transaction fee that's charged for reversing it. And then when you rebill it for the proper amount, there's a transaction fee for rebilling it. So it gets very complicated. But I'm not suggesting that you don't study it. And I think there are people out there that can come in and maybe ask them to work as a committee from the PBM side, from the pharmacy side, and educate the board on this. I know that, for an example, CPHA has an academy, or actually it's a special interest group now of managed care. They're very knowledgeable in it and can help, and we've got a lot of practitioners, but it's more complicated, and it really got complicated January 1, 2006, when Part D went into effect for the federal government, and now they're all over this. So, you're going to get a lot of complaints, I think, if you may not be able to do anything about it, but at least you'll understand it, and you may result in knowing how to refer it to someone who can do something about it.
It sounds like you're anticipating a large amount of partial fills on Schedule 2s because of this. Why would people do that?
First of all, there's a lot of publicity, and go ahead.
Well, all I was going to say is part of it is to reduce the quantity of opioids that you would get
Right.
at any one time, especially Schedule II drugs. So if you're having oral surgery and you only need perhaps a 3-day supply of pain meds, the prescription could be written for a 30-day supply, but you only get the first 3 days, and then if you need more, you go back. If not, you're done. And then you don't have this disposal problem or potential health risk sitting around your home where someone could get into it.
Aren't some
And-
pharmacies
Sorry.
also putting in max fills on some C2s? They're saying that they can only fill so many
That's-
on the retail pharmacy
A lot of
side.
them are using 7 days.
Yeah, but if
you're-
they get a 50-day supply or something, they're going to cut it.
Yeah, there are some pharmacies that regardless, even before the law went into effect, they said, we're only going to fill a 7-day supply. And if that's not acceptable to you, you can take it to another pharmacy, but they've said that their policy is like a 7-day supply. But the law changes July 1, so that legally, California pharmacists will be able to issue a partial fill on a Schedule II at the request of the patient or the prescriber. Until July 1, that's illegal, but it's already legal at the federal level. And before that, remember, Greg, there are no refills on Schedule II. So this is the way to get around the law that said there are no refills. You do partial fills.
To see the prescriber again,
Okay,
yeah.
so I think for the committee's purpose, the discussion is really whether or not you want to make this a strategic planning goal or to perhaps put it on a future agenda. I think those are kind of the two options, because this particular issue of the partial fill isn't really on your agenda today. So that's your focus, is whether or not you want to have it be a strategic goal and recommend that to the board, or to have it maybe be an agenda item.
You
at a
know,
future
I
meeting.
think, I'm inclined to have it be a future agenda item rather than a strategic goal. I
agree.
I think that while it does have merit and it does have importance, it's the other goals for the functioning of the board that we've talked about are of higher priority. But Danny?
I just want to add real quick, yes, we do have a SIG dealing with managed care that can help with this. Additionally, we have also identified this problem on the Medi-Cal side, and it's a particularly big problem on the Medi-Cal side because Medi-Cal has rules that they can only, patients, the beneficiaries can only have 6 fills a month, and, or I'm sorry, 6 dispensations, and I think, Steve, correct me if I'm wrong. Okay, well, there's a rule that back in January we found this problem, and we started to work with the Primary Care Association because they found out about this as well. So we're working with Assemblymember Arambula, who wrote the partial fill bill last year, but that 6 per month issue has been a big issue for both pharmacy and for patients. So we're trying to figure out a way to fix that, hopefully this year. So I wanted to add that on the Medi-Cal side, it's also a big problem.
Is your point that each partial fill counts as one of those dispensations? Okay.
Yes,
I want to make
DACS.
sure that's what you meant.
Yes, DACS, because we called ACS and asked them, does that count as one fill? And they're saying absolutely. So that has negative consequences for the patient.
Okay, thank you, Dan.
Time to get back to the Bates and the Remington.
That's right.
Definitely a consumer issue. You'll at least need to know what the law says.
Okay, so we've got, let's see, so we've got those 3 motions that, from that. Should we pick responsibility? There's not a motion on the floor.
And on that one is to make it a future agenda
Yeah,
item.
right, okay.
Do we want to also look at the pharmacists in charge and how they're held liable? I know we've talked about, there's some states that have actually moved in a direction where they're not holding the PIC responsible, but it's more the store owner. Is that something we want to consider? Just throwing that out there as an option.
Well, as I've mentioned before, the individual responsibility placed on the PIC license is overwhelming, and they don't have the power. They've got responsibility, but not the power. And one of the main advices that PICs give to students doing rotations is don't become a PIC. And so, that's universal. And so consequently, we're driving competent people out of those positions of responsibility. So I think that we should address this, and I think this is a priority issue. And entertain a motion to.
Second.
So
And
You may want to
just-
see what other, I know there's 2 states, I was actually at NABP, there was actually a presentation that actually took place. I think it was Idaho State has actually now no longer holding PICs responsible. It's now just the pharmacy and the owner, the business owner, and I think Maryland is the other one. But it just may be worthwhile looking at what the other states are doing. And I'm not saying that that's what we need to do, but it may just be maybe worth looking at it.
So do I understand correctly, this is also a goal to be
Right.
Recommended
Right,
as a
right,
strategic
right,
planning
right.
goal?
Maybe the way to phrase it is just look for the optimal level of responsibility that we're assigning a PIC versus the owner when issues arise.
I want to look at it a little more distinctly, not a balance between PIC and owner.
You want it to be just to remove the PIC, is that what you're saying?
No, I think we should review and optimize the balance between the responsibility of the PIC. Let's look at that, and then if in the discussion, it might fall on the owner from there.
So moved. Oh, wait, I think Stan moved that. Are
Okay.
you okay with that modification, Stan? And I'm okay with the second.
Okay. No board comment, public comment? All those in favor? Unanimous, again, okay, great.
You're on a roll.
Oh, I'm so popular. Okay. Oh, okay, sure.
Steve Gray, a pharmacist. Regarding Strategic Goal 2.2, which is regarding the consultation, I know this has been a passion, especially of President Stan Weiser when he was for many years, and as was earlier discussed, I don't think it's been resolved. One of the things that Ann brought up, and I think she was right on, was if you look back at Attachment 7, there are cases assigned and pending, and then it breaks it down into about 8 or 9 categories, and consultation is not itemized there. And I think what you were getting at was giving the board more data specifically on this because it is a strategic goal, and maybe breaking it out. I presume now it's up there in the top one, which is compliance and routine, generally speaking. So I think anything that's a strategic goal should have its own reporting so that you can get the data on that.
Oh, that's good.
And then just the other thing that Josh Roomer mentioned was in those cases which were filed under Civil Code 17200 as by the county district attorneys, which is a unfair business practice statute. And they brought, on the several $100,000 worth of civil fines. And as he mentioned, there were also integrity agreements that they signed. I'm not sure the board is aware of those integrity agreements. You might want to have a discussion at some point about what the board's role would be in, monitoring those integrity agreements, because I don't think anybody else is, to be honest with you.
I'm not sure we want to talk all about some of what we're doing there.
Yeah, but, and I agree. But it was mentioned, for an example, I think Mr. Lippy or someone said that one of the defendants' organization, they just had the patient check a box, at the clerk level, that they refused consultation. One of the companies that was involved in that, they changed the box. And it doesn't say that I refuse consultation, it says I receive consultation, and then you're supposed to put in a number on 1, 2, or 3, or 4 prescriptions. And so I think they actually lived up to their integrity agreement by not having checked where you denied, they just put in there and the difference. And personal experience in taking care of my uncle, the clerk just reached over and put in a number. And so that's
Very
how they're
efficient,
having it,
very
right?
efficient.
So there was no denial, but there was no really acknowledgement either that they got consultation.
No initiation of consultation.
That,
which is
that's
the
exactly
violation.
right. So I think there's a lot to be addressed, and I think as you start getting the data, you'll find out that, yes, I think there were improvements a few years ago as the word got around, but with everything, it's drifted back often into what it was before. And it is unfair competition because the independent pharmacies that, and others, and even chain pharmacies that are fully compliant, are at a disadvantage over those that just say, here you are, ma'am, and they go their way. So I would suggest, again, just to summarize, having a specific data report on that, and then maybe get involved a little bit with, finding out what those integrity agreements really, what they promise to do. I have gotten calls from several district attorneys in counties that were not affected, wanting to know how they can get in on this, but that might be something that you think about too.
Thank you, Steve.
So I think Steve raises a good point that we may want to consider on every one of these goals. Is there a KPI or a measure that we can attach to it so that we can assess our progress? Do we need a motion for that, or you think we can just do
So
it?
I think once the board votes on these, right, because the board has to vote on them as well, and then we'll talk through what the measurements will be and those kinds of things.
Okay. So, since we've accomplished so much with so many motions, let's take about a 10-minute break.
Couple minutes late for me.